Jimmy Johnson. Listen to the Kelly Show every Monday starting at 5 p.m. They can sure use the attention.
And this is former Major League Baseball player, Hall of Famer Wade Boggs. I also hope you listen to the Kelly Show every Monday starting at 5 p.m. They can darn sure use the money.
Hi there. This is marine wildlife artist and conservationist Dr. Guy Harvey. Please listen to the Kelly Show every Monday starting at 5 p.m. They need to feel worthy.
From the Sunshine State, this is Tampa Bay's TAN Talk.
It's time for FLA Law, brought to you by the personal injury attorneys of Perinick, Caulfield, Averill, and Noyes. This hour will be informative, along with taking your questions and comments. Now, here are your hosts for today's show.
Good evening. This is attorney Matthew Noyes, and I'm one of the partners of the law firm of Perinick, Caulfield, Averill, and Noyes. And we are the proud producers and providers of FLA Law on the radio every Tuesday here on this channel from 5 until 6. We are a live legal call-in talk show, and we are here to answer your questions regarding the law. Our firm is a personal injury law firm. In fact, we're the oldest personal injury law firm in Tampa Bay. We started helping people after car accidents and other types of personal injury matters in 1955, and we've been fighting insurance companies ever since then. And so we are here to answer questions that you may have regarding our areas of law, which is personal injury, car accidents, trip and falls, even workers' compensation and Social Security disability. But we're also here to answer other questions that you may have regarding the law. So I encourage you to get on the law line. Give us a call at 727-441-3000 so we can answer your questions. I'm not here alone. I have my friend and my law partner, Lori Robinson, here again this evening.
Always great to join you.
Lori, thank you very much. We spent the whole day together, so
yes,
I get to spend another hour together, too, with our listeners. Why don't you just give our listeners, I mean, you've been on many times before, but just give our new listeners a little bit about yourself.
Sure. So I'm a Clearwater native. I've been with the firm for 25 years now. But my particular forte is, of course, we do civil litigation. I'm a board-certified civil trial attorney, which I was actually able to acquire that distinction when I started with the firm 25 years ago. So I've been practicing a little bit longer than that, maybe twice. Not quite twice. No, it's not quite twice.
Not quite twice.
But anyway, after law school, I went to West Palm Beach and practiced down there in the public defender criminal area, and then went into private practice in civil litigation. Came back to help my mother about 30 years ago now. I don't know where the time goes, and then practiced over in Tampa for a number of years, and then came to work at Perinick, Caulfield, Averill, and Noyes, then Perinick and Carroll. But it's, as you point out, it's the oldest established personal injury law firm in the Tampa Bay area, and I'm so glad to have been a part of the firm for so many years. We have a wonderful opportunity to help people that end up being injured as a result of no fault of their own, and help them to get their lives back in order and achieve some level of compensation for what they've gone through. So I love doing the program. It's always nice to pontificate a little bit and then answer any questions that people might have.
That's right. And our website is voiceoftheinjured.com. And that's really what we are. We are the voice of the injured in a legal system and in the insurance arena that tries to muffle their voice and don't let them speak. So,
right. Oh, yes.
So you've heard us speak, and but you can also see us speak. I would be remiss if I didn't tell you that we are also on live Facebook right now. So if you want to see Lori and myself here on the radio on Facebook, go to the firm's Facebook page at Perinick, Caulfield, Averill, and Noyes Injury Lawyers, and you'll see us live for the next 50 minutes. And if you don't want to call with a question, you can send a comment on Facebook, and we'd be happy to address that comment here on the air. You don't have to have your voice on the radio. But if you want to jump on the law line, this is the time to do it, 727-441-3000. Lori, before we take the calls, I did want to talk about really 3 cases that happened just in our area in the last week that really emphasizes the need for lawyers like ourselves, and also the need to educate our listeners about what they can do because these situations happen. The first one I want to talk about is the Clearwater police arresting a driver accused of fleeing after hitting a man on a scooter.
Oh, gosh.
This happened just a few days ago, actually. What happened was the gentleman, Chris Patterson, was driving a 2021 Dodge Ram pickup about 2:45 in the afternoon when he made a right turn from a business parking lot to go east on Gulf to Bay Boulevard near Hampton Road.
Sure.
Which happens to be close to the Hooters restaurant right there.
That's true.
Well, as he made his right turn, he hit an 80-year-old man who was riding a mobility scooter. So does the at-fault driver stop? No. He kept driving east on Gulf to Bay at a high rate of speed. He did stop about a half a mile away to remove the scooter from underneath his truck.
Oh, my goodness.
And he drove away.
Wow.
After being arrested, he admitted that he was aware that he ran over something, but he was not aware that it was a person. And he was running late for work.
Oh, gosh.
Unfortunately, the 80-year-old man is in critical condition at St. Joseph's Hospital.
Oh, wow. That's a terrible one.
Yeah, it is terrible. I mean, it's for multiple reasons. I mean, accidents happen, but this fleeing the scene after leaving a business establishment at 2:45 in the morning and not even taking any steps to make sure that the person okay is just outrageous. We have situations that like this all the time with a hit and run, so to speak. What does this 80-year-old man, what kind of protection does he have in the system? What kind of claims can he make against this 37-year-old man from Port Richey who is driving a 2021 Dodge Ram pickup truck?
Well, we're going to hope that the gentleman was well insured for liability insurance coverage because he certainly was egregiously negligent. I mean, obviously, we can, you can look at this any way you want to look at it, but to have struck the gentleman on the scooter means he wasn't observing what was happening. Could have been some issues, obviously, that might have clouded his ability to perceive it, and then to have driven on when he knew something had occurred is, incredible. So, but just on the base level, obviously, it would be negligence. We hope that the 80-year-old gentleman will hopefully recover, but it sounds like he may have some pretty significant injuries.
Right. What about punitive damages? I mean, people always think, "Oh, we're going to get punitive damages." Can we easily get punitive damages in a auto accident case? Not
really. I mean, so of course, there is on the initial level, as lawyers trying to help people achieve as much compensation as possible for a terrible loss, we're always looking at what is the best avenue to pursue. There is the concept of punitive damages for especially outrageous, egregious conduct, which this might arguably meet, but in truth, there are limitations on how much you can recover. The legislature has capped those with recent legislation to 3 times the actual damages. And without getting into the weeds on that, it's basically capped. And then the other part of it is if there's special pleading requirements. And I would say, frankly, even more important, to be honest, is that it's not something that's going to be covered by insurance.
Right.
So in truth, the things that make us angry about that set of facts, just taking them from the newspaper article, obviously, or whatever the news article, those are things that I would prefer if I were representing the gentleman that was injured. I would prefer to focus on his damages, the emotional distress, and everything else that he obviously will have gone through, and allow the jury to factor in how egregious this is in an ultimate award, which honestly is how people do look at things, even though technically the punitive aspect is not supposed to come into play for damages that would compensate your pain and suffering. I think it does for most people. You look at that, a part of, and honestly, for what this gentleman would have gone through, I mean, because obviously he would have assumed he would have been visible, I'm sure. I mean, that would be an area that's reasonably well lit, even though it was obviously early in the morning. But
No, it was in the afternoon.
Oh, it was the afternoon?
It was 2:45
Okay, I
in
thought
the
you were saying- okay.
afternoon.
Yeah, then obviously, so it was just
Yeah.
completely not paying any attention on the part of the driver, the truck driver that caused this.
Right. And a DUI, not that there's any indications
right.
it's a DUI in this case, but if there is a DUI, that doesn't automatically entitle the person to punitive damages anyhow.
Right.
There's a whole process that needs to go through, a whole evidentiary hearing that needs to go through before the plaintiff, the person that was injured, can even make a claim for punitive damages.
Right.
And as you talked about, the insurance company doesn't really care because they don't have to pay for punitive damages.
Right. Yeah. So in the long run, as we have discussed many times in our shows, that the ability to achieve compensation is largely limited by a person's insurance coverage.
Right.
Yeah, that's the reality of it. And
Right.
most times you're not going to be able to make a collection against a more or less average person unless they had tremendous assets, which is
Right.
not the usual situation.
And assume that this 80-year-old didn't own a vehicle. There's a way that he can get the PIP coverage from the at-fault driver, right?
Yes. So if he didn't own a vehicle, then he would be entitled to the personal injury protection, which pays 80% up to $10,000 of the medical bills if he did not have any automobile coverage. So he would be able to, and I imagine given this accident,
That bill's already
right, and he presumably has Medicare or something, but because of his age. But
right
yes, $10,000 would be eaten up
on an
very
ambulance
quickly.
ride, just
Right.
about.
Yeah. So I don't.
And if the injured man does have own a vehicle and he does have auto insurance, what type of auto insurance would we be looking for as a plaintiff's attorney to see if we could help?
Right.
help him?
So obviously, in addition to the medical bills, that small coverage of PIP, as it's referred to, we'd be looking to see if he had uninsured motorist coverage. So in the event that the truck driver had limited coverage, which in a situation like this, I'm going to speculate the damages could be quite substantial.
Sure.
So, maybe the truck driver has $50,000 in liability or $100,000 in liability coverage. Maybe he has no liability coverage, but he has the truck, probably has some. But that would, under uninsured motorist coverage, if the gentleman that was on the scooter and was injured, if he had that coverage, then he'd have some ability to recover damages, even if the truck driver had very low limits of liability coverage.
Right. And we always talk about it every Tuesday between
Yes, we
5
do.
and 6 o'clock.
Yes.
We always want our listeners to hear at least one time
Yeah.
how important uninsured motorist coverage is. It is something that's voluntary, but it is something that's so important because not only is uninsured motorist coverage voluntary, in the state of Florida, bodily injury liability coverage is not required either.
Yes.
And so there's too many people driving around that don't have bodily injury liability coverage that may cause an accident, and the injured person may not have an avenue to seek compensation for
Right.
their unpaid medical bills, their lost wages, and the other intangible damages that they would otherwise
Absolutely.
be entitled to. So uninsured motorist coverage is the most important coverage to have. And we always encourage our listeners to check their policy before an accident to make sure that they have uninsured motorist
And
coverage.
of course, I think we've talked about this before, but now things have changed. Now, maybe the gentleman's 80, so if he had coverage, maybe he would do it the old-fashioned way with an agent or whatever. But many people today will just go on their computer and electronically secure coverage. And the law, uninsured motorist coverage is so important that the law actually requires the insurance company to give you the chance to affirmatively reject it so that your attention is drawn to it. But if you're doing things with a click, 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 electronic signatures and all that online, it's very easy to miss the importance of it. And,
Right.
and most people actually will not even understand or appreciate what uninsured motorist coverage is until they've gone through an experience where they find out that if you don't have that coverage, there's a reasonable chance that if you are in an accident, you're not going to have adequate insurance to cover all of the injuries and damages that you sustain.
No, I agree. There was a few months ago, we met with I think in 1 week we met like with 5 different clients after car accidents, and 4 of them, the at-fault driver didn't have any liability coverage, and many of them didn't have uninsured motorist coverage either. And so, although you can make a claim against the at-fault driver and get a judgment against the at-fault driver, without insurance coverage, it's not worth the piece of paper it's written on.
Really isn't.
Unless they win the lotto.
That's right.
All right. If you have questions regarding uninsured motorist coverage or car accidents in general, call the law line at 727-441-3000. But another one I wanted to talk about with you, Lori, also is something that happened on Friday night. It was taken out of the St. Pete, I guess it's not the St. Pete Times anymore, the Tampa Bay Times.
Or something, whatever it is now.
The Evening Independent. No, I don't think it's that anymore. But the article was driver charged with DUI after crashing into highway work truck on Courtney Campbell Road. Clearwater Police Department officials responded to a crash early Friday morning on the Courtney Campbell Road involving a drunk driver and a highway work vehicle. The crash occurred at 2:43 a.m. I always tell my son, nothing good happens after midnight.
Yes.
And what happened, the driver crashed into the rear of a road work vehicle that had its emergency lights activated and was stopped. One worker employed as a Department of Transportation subcontractor was taken to Meese Countryside to treat for injuries. The at-fault driver was charged with DUI and property damage, and it was taken to Pinellas County Jail after being medically cleared at the local hospital. So we have one that happened at 2:45 in the afternoon.
Yeah, right.
And we have a drunk driver that occurred at 2:43 a.m. that smashed into a highway work vehicle. Really, this causes me to think of 3 different things. One is the move over law. And the move over law in the state of Florida requires every driver to move over 1 lane away from any vehicles that are stopped on the side of the road, whether that's a police vehicle, a towing vehicle, an ambulance, a highway working vehicle, or even a stalled vehicle that's on the side of the road. It requires you to move over. Well, this person certainly didn't move over, and so they're in violation of that. But the highway worker who's injured, what types of claims would they have as a result of this DUI driver?
So they're going to have 2 places they can go to seek compensation. One, they would initially, since they were working, this would be a workers' compensation claim that would be so that they would have entitlement to medical coverage and wage loss if that occurred through the workers' compensation system.
Right.
But they also would have a separate, what we call third-party claim against the at-fault driver, the fellow that slammed into the vehicle there, instead of moving over like they should have, and a type thing. So there would be I'm going to call it a personal injury claim for damages, medical, pain and suffering, lost wages that would be directly against the driver that caused the accident. Driver. Yeah.
Now, workers' comp provides medical care, and it provides a certain percentage of the wages if they're out of work.
Yes.
But tell our listeners, who gets to pick the doctors in the workers' comp arena?
It's very limited system, the workers' comp system. So the workers' compensation insurance carrier for the employer will be the one that sends you to doctors that they have contractual relationships with. So it's a specific list, and those doctors will be paid under a workers' compensation fee schedule, which is substantially less than regular health insurance or any other. So it's not that you couldn't get a good doctor. You possibly could.
There are some good workers' comp doctors.
But they're all working in a system that's extraordinarily limited, and the whole goal, which is not that you don't want to, if you have an injury, you want to get better and get back to work kind of thing. But because of the limited nature of the workers' compensation fee schedules and just the pressures of that system, the realities of it, it means that you're very unlikely to get the same, I'm going to say, opportunity for care that you would get if you're selecting your own doctor, obviously,
Sure.
Which you'd have more opportunity, and actually would have the opportunity if you're treating outside of workers' comp. But it is kind of tricky because you do have, it's a decision to make, because if you're injured while at work, then that is something that should be handled through the workers' compensation system. You could elect to forego that, but that would be a fairly big decision depending on what your situation is, because if you do not treat under workers' compensation, there are going to be some limitations about when you would be cut off from doing that.
Sure.
You have to report it within 30 days. In a situation like this, that would be sort of on record. I don't think that would present an issue there. But if you let a couple of years go by and never ever pursued a claim, then you could potentially have some issues.
And if you do pursue the workers' comp claim and you do treat under workers' comp, some people believe that, okay, I'm treating under workers' comp, so I can't treat under my PIP or and the reality is, no, you can really do both.
Yes.
What we always tell our clients, because we handle both auto accident cases and workers' comp cases, is that we tell our clients that as long as the work comp doctor knows what the other doctor's doing and the non-work comp doctor knows what the work comp's doing, then we don't see a problem with it.
Right.
Workers' comp carrier would have to pay the work comp doctor, and the PIP would have to pay the non-workers' comp doctor.
Yes. And so you do have those options, and often you'll want to avail yourself of them because of the limitations of the workers' comp part of it.
Now, assuming that we did have a workers' comp claim and you treat under workers' comp and you get wages under workers' comp, the most you can get under workers' comp and wages is 66 2/3. And that's if the doctor has you out on temporary total disability benefits. But what about the other 1/3 of the wages that you don't collect? Where would that person be able to collect that unpaid 1/3 of wages?
That would be a damage that you could claim and recover as a part of the third-party negligence claim against the at-fault driver, which is presuming that driver has that caused the accident has liability insurance sufficient to cover the damages. And if they don't, if you have an uninsured motorist, you'd still be able to recover those types of losses that are not covered under workers' comp. And of course, the biggest one we know that isn't covered under workers' comp is anything related to what you go through, the pain and suffering, the distress, the whole inconvenience of having had your life completely turned upside down because somebody behaved in a negligent fashion and caused an automobile accident.
Right.
Those things can never be compensated under workers' comp. It's just the nuts and bolts of that limited wage compensation, and they pay the medical.
And assuming that workers' comp does pay wages and the medical, I've seen one too many times that a personal injury attorney handles a case that doesn't appreciate the impact of the workers' comp carrier paying. What rights does the workers' comp carrier have in order to get paid back?
Right. So, of course, the workers' comp carrier is going to feel, and they will be correct under the law, that they have a lien against any settlement or financial recovery, like if you went all the way through a jury trial in a third-party action against the at-fault driver. If you recover an amount of damages that includes medical or wages, then the workers' comp carrier will have a claim to be reimbursed. Now, like all things, it turns out to be a little bit complicated what they're entitled to recover, because in most instances where cases are going to perhaps be settled, there'll be a question about whether you did in fact recover 100% of your losses, because of course any settlement is going to take into account both your medical expenses, your wage loss, your pain and suffering, and all of that. So it ultimately becomes a bit of a negotiation usually as to what the full amount of your claim really was and how much you actually recovered. But the bottom line is it's actually a fairly complex issue. And unless you have an attorney that actually does handle both the workers' comp and personal injury, regular auto accident cases, they don't necessarily appreciate the complexities of that.
Right. And we've seen clients and attorneys getting into a pickle because they've settled the case, and all of a sudden it's like, oh, there's a workers' comp lien we got to deal with.
Yeah.
And so we together, we work together with other personal injury law firms or attorneys that don't necessarily handle workers' comp. And so we help them with the workers' comp aspect of the case while they handle the third party case. And then when it comes to the workers' comp lien negotiation, we can work and try to protect the client, the injured person, the best that they can to maximize their recovery.
And it's a whole little bailiwick. I mean, workers' comp is its own system. So it's something that if you haven't been involved with it, it's, it can be kind of confusing.
Right. And I think the most thing clients sometimes get upset because they say, well, why do we have to pay back workers' comp? It doesn't make sense. But when we explain to them the double recovery, that if the auto insurance is paying for your past medical bills, but workers' comp paid for your past medical bills, you can't recover from both workers' comp and the third-party insurance company as well. But as you mentioned, the lien would always be reduced by the attorney's fees and costs because the client had to pay the attorney's fees and costs in order to recover the third party part of the case.
Yes. And so there'll be a number of considerations, and that's one that would be easy to understand. Whatever you recover, if you had to pay the attorney fees and costs, obviously you did not recover 100% of what you of those damages. So that would, and there can be other factors.
Yeah, comparative negligence is a factor that comes into play when you're trying to negotiate the workers' comp lien. The limited insurance coverage is also something that comes into effect. And something that's also interesting that sometimes people don't appreciate is there is a lien on the third-party liability case. However, there is no lien on an uninsured motorist claim.
True.
So now in the last 30 minutes, we mentioned uninsured motorists 3 times. So hopefully our listeners appreciate how important uninsured motorist is. But that's all this information that's so important that a representative, an attorney who's helping somebody fully understands so they can best represent somebody.
Now I'm going to say, using your favorite metaphor, this is a little bit of inside baseball, isn't it?
That's exactly true. That's exactly true. So it is important if you're involved in an accident while at work caused by a third party, it's important you talk to an attorney that understands both things.
Right.
Just to make it a little more muddier.
Yes.
What happens if you're driving in a vehicle driven by a coworker and the coworker causes a crash and you get hurt? Does the injured person have a claim against the coworker?
Well, I'm not sure on that one.
The answer is no.
I didn't think so, but I'm not going to say
the workers' comp immunity extends
even
to the
employer, co-employees and the people that you're working
and
with.
coworkers.
Yes.
So
So if they were truly a co-worker with the same employer, now what if they were working for a different entity?
That they would have to. It depends if there was a general contract. If it's construction, if it's a general contractor, is it, not to get too technical, is it horizontal immunity or is it vertical immunity?
This is really inside baseball.
So this is really insight, or just really to let the listeners know how complex it really is.
Yes.
It's not simple. Which is really weird for me, is I always try to give the scenario. I used to be a waiter at Denny's restaurant, and so I give the scenario that when I was a waiter, if I was walking with a customer and an employee negligently spilled some water and didn't clean it up, and myself and the customer fell on the same puddle of water, and we had the same exact injuries. Let's say we dislocated our shoulder. We had the same exact injury, and lost the same amount of lost wages and everything. The customer would be able to make a claim against the employer for all those damages, but me as the waiter couldn't make a claim against the coworker and couldn't even make a liability claim against Denny's for the negligence that their employee caused.
But what if it was a highly polished waxed floor and they contracted that out?
That's where the question then becomes. But yes.
Yeah.
All right. Well, so if you have questions regarding getting hurt at work, whether it's a third-party case or not, Lori and I handle a lot of work injuries for a lot of good people who work really hard and get hurt. So we're here for the next 40 minutes. Call us on the law line at 727-441-3000, and we'll be happy to tackle your questions that you have. One last thing I wanted to talk about in the news, so to speak, is, since we're on the topic of workers' compensation, the article recently came out. I think it's in today's paper, quite honestly. It says, how much does high heat increase workers' injuries?
Oh, interesting.
And a new study shows that it has a lot of impact on workers getting injured. The new study shows it cites a strong and robust evidence that excessive heat increases the frequency of work injuries. With risk, particularly in the South. Well, of course. In part, it found that the probability of work-related accidents increased by 5% to 6% when the maximum daily temperature tops 90 degrees compared to days when temperatures were in the 70s. So it also cites a clear increase of numbers of days of temperatures over 90 degrees. Well, welcome to Florida.
Yeah, I know. So we must have very high incidence of work injuries compared to other places.
Right.
Yeah.
And they talk about both direct and indirect injuries. For example, a direct injury would be somebody who faints because of heat exhaustion. An indirect injury is that they faint and they fall off the ladder and they break their arm.
Sure.
Workers' comp is kind of tough when it comes to heat injuries, heat exhaustion injuries, because it's not really an accident that happened. We have to prove an accident happened and that the accident is the major contributing cause for your need for treatment, unless it's an exposure case. And would heat be an exposure case? And under the law of workers' comp, it's a higher burden for the injured worker to prove that the need for treatment is because of exposure. Instead, we have to prove not a more likely than not, but a higher standard to show that the exposure to the elements is the cause for the need for treatment.
So somebody on a rooftop when it's 90 degrees, I mean, that would certainly seem that is putting the person in an environment related to their work that is the major contributing cause.
Yeah, but it has to be more than major contributing cause if they don't have a physical injury.
All right. Well, that's a little,
because if they fell off the ladder, well, then they have an accident. But if they just pass out,
just have a heat exhaustion kind of thing,
right?
Yeah.
Then you have an exposure type of case, and it's a higher burden for the employee to try to prove that they're entitled to workers' comp benefits.
If they're so you're the master on all this, but if they're on the roof and they fall off the roof as a result of the exposure and are injured, that's covered.
That would be covered.
But if
under the major contributing cause burden of proof.
Yeah. But if they had to go to the hospital because their electrolytes were low, et cetera, they were just out on the roof, even though it is being on the roof as a roofer that is putting you in that position,
right?
Then it's a much
you still
more
have a higher burden.
Yeah.
It's crazy. I don't think it's right, but unfortunately, that's what the law is.
But it also is the kind of thing which I would say, having been a lawyer for many years, and it's what I love about it actually is, you always are going to look at legitimately so, at an angle. So if you have a situation like that, let's just say, some poor fellow, could be a girl these days, but most likely fell up there on the roof and something does happen and it gets denied. It's still something that you should be reviewing, because these are things like, there are some cases that you see all the time or enough that you're going to have an answer to it, but there are also going to be other things that a lawyer in that field, such as we are, would take a look at, research. We'd want to review it before we would conclude with certainty that there's not a claim to be made.
Certainly.
Right?
Yeah. Whenever a workers' comp carrier or even an auto carrier denies a claim, it smells funny to me.
I'm thinking of the cases we've had over the years. I can think of a couple of them where a person is injured, tripping or something like on the parking garage, and it's kind of connected to where they work. That's where they're supposed to park.
Right.
They're coming to work. There are all these different things that come into play with whether it's going to really be covered. And it might seem like it's not on the surface, but it really requires a closer examination to see if it should be. Because honestly, if it's something truly connected to the work, it should be.
Certainly. And so I encourage all our listeners and our clients too, that if an insurance company denies the claim, talk to an attorney.
Yes.
See if that denial is actually the denial. There's a little thing that we plaintiff lawyers tease some big insurance company that they first deny and then they investigate,
right.
And really it's supposed to be the other way around, especially in the workers' comp arena, because there's this period of time
right.
That the law says that, listen, you can pay and investigate in this period of time, and it's 120 days. You can pay the benefits, the medical care, and the wages without being held responsible should the investigation show that it is not work comp related. But we don't see that too often.
No.
We see the denial and then the investigation after an attorney gets involved and says, wait a second, why was this claim denied?
Yeah.
So it's a battle that we do. We enjoy fighting for it. And, it drives my wife a little crazy because there's something in the news and it says, well, we think about how we can help that person the best way we can. Then she's like, well, gosh, I never even thought about something like that. And I said, well, that's why we do what we do, But so if you have questions, we do have about 17 more minutes left. So give us a call on the law line at 727-441-3000. I'm Matthew Noyce. That's Lori Robinson. We are two attorneys at the law firm of Perrin at Caulfield, Averill, and Noyce, the longest established personal injury law firm in Tampa Bay. We have been helping people since 1955 after their car accidents, trip and falls, work injuries, and Social Security disability claims. And so give us a call with any questions that you may have. Lori and I combined have over 70 years of experience in legal. And so I think we can probably tackle any question that you may have. And me being on this side of the mic, I can always just lateral it right over to Lori and make her have to answer that question. No, but please feel free to give us a call at 727-441-3000 or type us a question on our Facebook page at Perrin, Caulfield, Averill, and Noyce Injury Lawyers, since we are live now. But Lori, before we get a call, why don't we talk about Social Security disability a little bit? Because that is an area of law that, we help, and we are a personal injury law firm that does Social Security disability, but we do a lot of Social Security disability. And we do it because, we see that people need help.
Yes.
And can you tell our listeners, just an overview of the typical process of applying for Social Security disability? Yeah,
I want to emphasize that I take a lot of calls that I will talk to the person as a kind of a professional courtesy to give them an idea about Social Security, because until you've been involved with the process, you really have no idea.
Right.
No idea at all. So Social Security disability, if you have, let's say you've got a situation where a person typically probably over 50, but it can apply under 50. It's just the rules are a little more strict. But basically, person is unable to work. They can't, they're in a situation where they're unable to work for 12 consecutive months. Either it's at that point, or it's obviously going to be that's going to be the situation medically. If in that scenario, then you can make an application for Social Security disability. With our clients, we will assist them with that process.
You found that that's better to help them through
yes,
the process.
Because it is. There are so many forms and the questions. I mean, when we started doing this years and years ago, we would kind of get involved after that. But now we've found that the people need the assistance, and it helps us to actually know really from the beginning what their situation is. So you apply for Social Security disability, and then the Social Security Administration has a whole process of review that currently takes months and months and months, maybe a year, possibly even a little longer, to just review that initial application. Once they review it, the vast majority of times it will be denied. Not always, but most people will have to go through what I call the long extended process. And
I think I saw a number, I think it said like over 85% of the applications are denied.
Yeah, I used to, when I first started doing this 20 some odd years ago, I used to hear the figure of 60%. It's probably more now,
right.
but it's definitely so. Unless it's a small subset of cases, that your basic experience is likely to be that long process. So the first application, initial application is denied. Then the next step is to ask for reconsideration, which really goes to essentially the same type of eyes, same type of review, different person. And then ultimately, after a few more months, typically, that's denied also. And then what happens, the next step after that is a request for a hearing in front of an administrative law judge. Those are done by video now. And those are actually scheduled pretty reasonably now. From the time of that request, maybe 6 or 8 months down the road, you get your actual hearing before a judge.
Yeah, they used to be like 18 months before the request.
That used to be the long part.
Right.
Now the long part, for whatever reason, staffing or whatever with Social Security, I don't know. But now the long part really is that the initial processing of the application and the reconsideration. But the whole process, when it's all put together, you're looking certainly at a couple of years for most people, before you actually get to a place where it can be approved.
Right. And are there deadlines to file that if you get denied?
Yes.
To take the next step?
So really, you have, once you do the initial application, everything in Social Security, they send you letters. It turns out it's like 60 days from the time that you knew about it. But, generally speaking, it's 60 days. It's hard. I think it would be hard for people to do it on their own. We see that. But the longer I've done Social Security, there's so many rules and nuances, and even understanding what they look for. Most people don't really have any idea what they're actually looking for. They're really focused on the person's functional limitations. So people will share with me, well, I have this condition or I have that condition. You have to have a medical impairment that is creating an inability to work. But what Social Security is focused on is, well, what can you do physically? What are your limitations? And then that they match against whether you could do your past work and whether there would be other types of work in the workforce that you would be able to do. But long process, one that most people would have no appreciation for, unless they had a reason to go through it or talk with somebody about it.
And a lot of the calls that we take initially that you're kind enough to talk to are calls like, I don't think I can continue to work.
Right.
So I want to file for Social Security. It's getting too hard to work.
Right.
What do we tell those people?
Yeah. So as long as you are in fact working at a level that's considered substantial gainful activity, which currently that's just $1,550 gross per month. So $1 more than $1,500 in round numbers, that you would absolutely be unqualified to receive Social Security disability. So when I talk to people in that setting, which I think makes sense, and we end up representing many people ultimately in that setting, they're really looking to plan. They want to understand, what is available and how they should plan. And so part of what has to be planned into any decision the person makes is that if you're at a point where you're not going to be able to work, you also have to factor in, I'm also going to have to wait for a considerable period of time before the benefits will be available to me in the usual case. And the other thing is for people to become aware of how they should be talking to their physicians and focusing on the problems they're having that relate to their ability to work, so that, of course, if there's treatment that can help, fantastic. That's the best case scenario, is to be able to continue to work. But if you can't, then those problems that relate to your inability to work will be documented in the medical record, which is so important in order to be successful with an application for Social Security.
What are the most common reasons why the initial claim is denied?
And almost always you're going to read something that will say, we appreciate that you feel that you are unable to work, but we have concluded, this is Social Security, that although you do have a serious issue, it's either not likely to last for 12 consecutive months, or we have concluded that you still have the capability to do other work. I mean, that's usually the situation, because it's not going to be just your work that you personally feel comfortable doing and want to do. It's really going to be, I mean, the rules, there are some nuances to this as you get older, but without getting too much in the weeds, it's really going to be, the way to think about it is whether you're able to do really anything. But once you're over 50, that's not exactly the case. There is a consideration that it's not as easy to adapt to other types of work after you are over 50, and then the rules become a little simpler yet after 55, and then as you get close to retirement age, simpler still.
But you still need documentation. You still need evidence.
Yes.
Why don't you tell our listeners, what kind of evidence or documentation do we need? A doctor saying this patient is disabled?
Right. That unfortunately, even your family doctor that knows you well may be delighted to try to help and may genuinely believe you can't work and will write a statement to that effect. I don't believe this patient can work. That is completely ignored by Social Security. In fact, it's almost like a red flag. They make their own decision.
And that's surprising to many of our clients.
Very surprising.
Say, well, wait a second, my doctor said I'm disabled.
It was surprising to me when I started doing this years ago, but they are not looking at that. What Social Security believes, and actually this is true, most doctors are not actually going to know what the standards are for Social Security disability so Social Security is looking at what's your residual functional capacity, meaning what are you actually able to do physically and mentally. I mean, there can be mental impairments as well. So that's what they're focused on. So what you want your doctor to do is put in their medical record what their findings are with respect to how much you can lift or carry, how much you can sit or stand, any problems of that nature. Those are things that can be quantified for Social Security's purposes, and that's really what they're looking at. So it is something. That's why
diagnosis alone isn't good enough.
No, it's really got to, and that's why I say it's always good to zero in with your doctor, even if you think that they know your situation, on what problems you're having. So if it's, if it's difficulty because of chronic pain and that you're constantly having to, you can't sit long, you can't stand long, give them examples so that they can try to help. Maybe there's some other medication or something, but if not, at a certain point, people will tell me, well, there's no point, the doctor's done all they can. Social Security needs ongoing current documentation of your limitations. So that's why you should be focusing on things that relate to your ability to work so the doctor can help. But if not, it's now in the medical record what those limitations are, because that's what Social Security will be looking at, not the doctor's opinion on whether or not you can work. Although obviously the fact that your doctor may feel that you genuinely can't will make it easier for them presumably to identify the things that are the reasons that you can't.
And May is Mental Health Awareness Month, and so I think mental health comes into a major part in our Social Security disability claims. Why don't we tell our listeners a little bit about how mental health can impact somebody entitlement or qualification
Right,
for Social Security disability.
So depending on the nature of the mental health impairments, but obviously many people deal with anxiety or the inability to be around people, to handle any kind of change, the depression, many different mental impairments can impact your ability to concentrate, to focus, to actually, if you were able to go into a job, to do it on a regular basis so that you could meet attendance requirements. But mental health issues are, by their very nature, things that are a little bit more subjective. So it is very important to talk to the psychiatrist. And also I want to emphasize that for Social Security, you do need specialty care. So your primary care physician might actually be wonderful and have a lot of knowledge about your situation, prescribe you an antidepressant or whatever. But if it's a situation that is actually preventing you from working and you believe that you would like to apply for a disability, you really need a referral to a psychiatrist, and you need to work through specialty care to try to get the help that you need, but also to document what problems you're having, because that's going to be very, very key to establish a significant impairment that's going to prevent you from actually functioning in a workforce.
Right. And as we talked about, this could be a 2-year process.
Mm-hmm.
So 2 years of attorney's time and legal assistant time.
Right.
How do we as the Social Security attorneys get paid?
Well, Social Security has a rule for everything, and they have one for this too. And so they set what the fees are, basically, and the fee is 25% of any back benefits up to a maximum, which they change from time to time. It currently is $7,200. That would be whatever the back benefits are. If it takes a couple of years, then they could be significant, depending on what your benefit is. The fee would never be more than $7,200. It will often be some less, depending on what the back benefit is. But that's established by Social Security, and then they just deduct the fee in that scenario. So it is a contingency fee. You don't owe the attorney anything unless there's a successful recovery of benefits.
So if the judge decides that the person is not disabled,
right,
then
there's no fee.
Yeah, they never get a bill from us.
That's correct. Yes.
What motivates you to do Social Security disability?
I would say actually today was a great example, even though we didn't take this particular case, but we may help the young man later. Just people, young man that is in liver failure, and just is unable to work now, doesn't know what to do. And so the Social Security cases in particular, all the personal injuries in this category, because people's lives are impacted, but particularly Social Security, when you reach that point, that's because there really are no options for you. No one likes to come to that place.
They need help.
They need help, right?
And they're at a point in their life where they just need somebody to listen to them and to fight for them.
Right. And it is a complicated system that people have no actual clue about, as I've said, repeatedly. So it's so to take somebody through that process, to know how to make sure the record is supportive, and to present their testimony well at a hearing, so that ultimately we are successful, is a great opportunity to help, and it just is so rewarding. Actually.
Right. And if anybody has questions, we're just about to wrap up the show now, but if they have questions about Social Security or work comp, personal injury, or car accidents, they can contact our office at any time. How would they contact us?
So, of course, you can call our main number, 727-796-8282. And obviously, you can, if you're good with the computer, usalaw.com or voiceoftheinjured.com will get us.
Or they can listen to us next Tuesday.
That's right.
At 5:00. I will be having immigration attorney Michelle Perez on the show next Tuesday at 5:00. So we appreciate you taking the time to listen to us today. I hope our information was helpful for you. Hopefully you never need us. We always meet good people after bad things happen. But thank you for listening to FLA Law on the radio. As I always say, drive safely and watch out for those who don't. Have a good night.